Hi, everyone, and welcome to the annual Santa Monica Landlord Tenant Forum. Thanks for joining us today. My name is Bridget Garay, and I'm the Consumer Specialist for the Consumer Protection Unit of the Santa Monica City Attorney's Office. We're really glad that you're here today and that you could attend this virtual event, and we hope to be able to hold this event in person again soon. Before we start, I want to let you know a couple things about our presentation. Today, this event is being recorded, and a recording will be available on the city's YouTube page or the YouTube channel within the next week. We're also going to have a question and answer session at the end of the presentation. So please type your questions into the chat at any time during the program, and we'll respond to your questions as best we can at the end of the program. So we have some great presenters for you today. They'll be discussing some very timely topics. But first, I'd like to introduce you to Etta Sa. She's the Consumer Protection Unit's Chief Deputy City Attorney. Etta, thanks for being here today.
Thank you, Bridget, for the introduction and for organizing and hosting this event. So every year around, sorry, can you hear me? Okay, so every year around this time, the Consumer Protection Unit and the Rent Control Board, together we put on this forum. And we treat this as an opportunity to inform, discuss, and connect with our tenant and landlord communities about important local issues and updates that affect us. We have been successful in carrying on this tradition, even during the most tumultuous of times. Most recently, when COVID-19 abruptly forced many of us to shut down our work, school, and regular activities, we continued on. In fact, it is probably during times of uncertainty that it is most important that we continue to reach out to our community. There's one thing I'd like to mention. It's a small but important one regarding contacting our unit. Going forward, calls to our unit, both live and voice stream calls, will go through the city's 311 system. The city's 311 team will receive the call, return the call, enter the information from the call into the citywide system, and then finally route the call to the appropriate department. This change is already in place and will continue going forward. Otherwise, the Consumer Protection Unit's procedures remain the same. You can still file a tenant, housing, or consumer complaint online or in person. And you can still email us at consumer.mailbox@santamonica.gov. At the end of our presentation, we hope that you are reminded that the unit's goals and commitment to the public remain the same. We work to protect the public rights of our community members and advance the interests of the people of Santa Monica. If you have questions, please call 311 or email us. And with that, I say thank you and enjoy the presentations. Thank you, Bridget.
Thank you, Etta. Our first speaker tonight is Daniel Costello. He's the Public Information Manager for the Rent Control Board. He'll be presenting you with information about the recently passed Measure RC. So Daniel, take it away.
All right, thank you. So yeah, I would like to welcome everybody also on behalf of Rent Control. I'm the Public Information Manager here. We have a few things to present today, actually a pretty full schedule, so we may go a little bit fast, but we hope that you can pick up as we go along. And so I would just like to start to talk about the adjusted general adjustment that is coming up. So as hopefully you know, Measure RC passed in the November 2022 election. And for the first time in Rent Control's history, we are going to have two general adjustments in 1 year. And I'll talk more about what Measure RC has done in a second, but if we could go to the first slide. One of the things that Measure RC did, in addition to giving us an adjusted general adjustment, was to modify the charter regarding some of the provisions around eviction for owner occupancy. So there were two changes really. First, the charter now requires owner occupancy within 60 days of vacancy of the tenant. This is actually an extension from 30 days, so it gives the owner a little more time to move in good faith. The other part of it extends the amount of time for which the owner must continue to live in the unit after evicting the tenant. So instead of 1 year, which was the former regulation, now it is a 2-year requirement. So owners who evict for owner occupancy should intend to live in the unit for at least 2 years, unless there are some extenuating circumstances. Okay, so let's go on to the meat of it, the adjusted general adjustment. Go to the next slide. Okay, so Measure RC, as I said, gave us an adjustment to the general adjustment that we normally announce in the summer, and that takes effect in September of every year. This year, due to high inflation, we had a maximum general adjustment of 6%. Inflation was in the 8%, and we used 75% of the change, and that would have been 6-point-something%, but the charter limits the increase to 6%. Well, with the passage of Measure RC, now the maximum in any year is 3%. So part of what Measure RC does this year is adjust the general adjustment so that by the time the entire year has passed, and our year goes from September of one year to August of the following year, that there would be an average 3% or $70 adjustment. The way we get there is this, and I'll give you some more examples of this coming up. But for units that had their maximum allowable rent, or MAR, adjusted or increased the full 6% per the September GA, those maximum allowable rents will now be recalculated, and there will be a 0.8% increase that goes into effect in February. You'll see when I show you some examples later how this ends up averaging to a 3% increase for the year. Similarly, Measure RC adjusts the MARs for units that were increased the maximum of $140 per year to a $19 increase effective in February. So that too will average a $70 increase over the course of the year. And finally, the other thing that Measure RC does is it says that the general adjustment that will be applied in September of 2023 will be based on the MAR in effect on August 31st, 2022, so prior to the September increase, plus 3%. So that will be the basis going forward next year. So let me give you some examples of what this looks like. So if we could go to the next slide, please. So the standard adjusted general adjustment is this 6% to 0.8%. So this percentage increase applied to tenancies or units that had rents that were $2,312 or less. For those, they got a 6% increase. Units that had a MAR above $2,312 got the maximum increase of $140 a year, and I'll show you that next. So to get to an average 3%, we have 5 months at 6%. So that would be September through January. And effective February, the new adjusted general adjustment is going to be 0.8%. And if that is applied over the remaining 7 months, That gets us to 35.6, which is as close as we can get to 36 and not go above the 3% that is allowed by Measure RC. So on the bottom line of the chart, you'll see on the lower left a sample rent of $2,000. So under the original GA, it received a 6% increase or $120 increase. Effective February 23, that MAR, the maximum allowable rent, is going to be reduced to just a 0.8% increase above 2000, which is 2016. And then when you add up the rent for the full year, you'll see that it averages out to 2060, which is a 3% increase over 2000. We go to the next slide. So here's an example of a unit that received the maximum increase this year. This had a rent of over $2,313. So in September, it received a $140 increase, which the tenants would pay for 5 months. And then in February, that $140 adjusts down to $19. And when you add all those months up and divide by 12, you get to $70. Using the example on the bottom, a $3,000 rent would become $3,140 in September, but in February, it has to drop down to $3,019. And when you average that across, you see it's $3,069. So as close as we can get to $70. Okay, if we go to the next slide. So one other thing that Measure RC allowed was that the Rent Control Board could adopt a regulation that would allow an increase after February that is greater than 0.8%, provided that the increase before that time was less than 6%. And again, we're trying to reach a 3% or $70 average. So the board passed Regulation 3035E, and it said that if the increase between September and January was less than 6%, then the increase after that could be more than 0.8%, but not more than 6%. It wouldn't work to get to a 3% average if that were allowed. So again, the average increase for the period from September through August is 3% or $70. That's what we're shooting for, whichever is less of those two numbers. So if we could go to the next slide, I'll give you some examples of how our Regulation 3035 might be applied. If an owner gave a 3% increase in September, maybe they didn't want to raise it the full 6%, because of the large impact on the tenants, those were often increases of more than $100. They may have just said, give me 3%. If that's the case, no adjustment is needed for the whole 12-month period because 3% across 12 months is going to average 3%. So a $1,000 rent that was increased 3% or $30 would be the rent that the tenant continues to pay through August 2023. So if an owner increased the rent 3% or less, there's really nothing an owner would need to do. Let's go on to a different example. So in this case, let's say the owner didn't increase the rent at all. Maybe the owner wasn't sure, what was happening with Measure RC, just wanted to wait to find out what was happening. Since they increased the rent before February of 23 less than 6%, they can take an increase after February or after that is greater than 0.8%. And in this case, it's they beginning in March. So they don't implement it in February. They can wait till March because 6 months of 6% from March to August will average 3% for the year. The bottom example, a $2,000 rent doesn't change at all until March, and then the owner could implement a 6% increase at that point, raising the rent to $2,120 for the remainder of the period. And that would average to a $2,060 rent. I have one more example. So here, an owner is using a dollar figure. So they didn't increase by a certain percentage, but they just gave the tenant a certain dollar amount that would have been below the 6% that was allowed or below the $140 that was allowed. For this rent of $4,000, a $140 increase would be allowed. So they charged the tenant $100 for 7 months. So after that 7 months, they now need to recalculate the adjusted general adjustment and give the tenant a notice that reduces the rent so that the average over the 12 months will be $70. This can seem a little confusing, but basically with a $70 average rent times 12 months, there's $840 to work with. And if $700 was spent during, or was paid during the first 7 months, then the remaining $140 could be divided among the remaining 5 months. And so that's how we get the $28. So let's move on to the next example as well. So this is a lot of information to cover. And I think that what I want everybody to know, all of the tenants and property owners of rent-controlled units, we are mailing a mailing this week, which you should receive at the end of the week or over the weekend or the beginning of next week. And it will include for all of the owners a MAR report. And that's something similar to the one that we send each summer in preparation for the September general adjustment. So it looks very much like that, and I'll show you an example of one next. But you'll have a MAR report, and we're also providing a notice of change in terms of tenancy template that you can use to notice tenants of the change in rent effective February 1st. Because the adjusted general adjustment takes effect February 1st, owners need to give notice generally 30 days before February 1st under California law. If an owner is not able to do that for some reason, we don't think that there will be a problem because ultimately you are reducing the tenant's rent, and it's not likely that anyone would have a problem with that or a claim. But we are encouraging owners to get these notices out as soon as possible. If we go to the next slide, I'll show you what the MAR report will look like. It's a little bit different from the one that we send in the summer in that we've added a column on the right to show what the average 3% increase is going to be when we get to September 23. But first, let me just go through the columns here. So each owner will get a MAR report for all the properties they own or manage. Then we have the market rate established. So the general adjustment only applies to tenancies that began September 1st, 2021 or before September 1st, 2021, because the tenancy has to be in place for a full year before it would get a general adjustment. So the first line, you see the tenancy began in August. That does not get any adjustment this year, so there is no change. Unit A, you'll see, had a rent that was below 2,312. So it received a 6% increase. The original MAR before the increase was 1606. It got a $13 increase, which is 0.8%. And the new MAR as of February 1st will be 1,619. The next unit shows a unit that has a rent that is above 2,313. And so it got the maximum $140 back in September, but now that is being adjusted to a $19 increase. All right, if we could go. So the last bit, so in addition to what we are sending you by mail, we will have a fillable notice of change in terms of tenancy on our website. We also have one that we call the EZ form, because it does not include any of the property tax surcharges that owners might not be able to pass through if there's a newer tenancy. And then we're also preparing a worksheet that will help you calculate this 3% or $70 average. I think that's going to be very helpful for people who want to collect the maximum that they can collect under Measure RC. And then finally, we will update the MARs in our database and on our Look Up a Rent page effective February 1st. So you will see the new MARs with the adjusted general adjustment. And I imagine there will be questions, but we will take those at the end. Thanks.
Thank you, Dan. So next up, we have Deputy City Attorney Jonathan Frank. He'll be presenting you with the latest information about the eviction moratorium. Jonathan, let me just get your slideshow up.
Great.
Okay, take it away.
Great. So first of all, thank you, Dan. I think that's going to be very helpful for this presentation as well. We're going to be talking about the eviction moratorium that is related to the rent control change. And I know I saw in the chat that some people are confused by that. Again, we will have time for questions at the end. So we can try to address that there. So I'm going to be talking about the temporary eviction protections in Santa Monica. And just as an initial point of clarification, I did decide to call it that rather than eviction moratorium, because I think it's important that we start thinking about this as, temporary eviction protections. It's not an across the board sort of rule saying that you can't evict someone. They're specific and often narrow protections, and many of these have already come to an end or will be soon. So can we go to the next slide? So here's kind of all the different moratorium that we'll be covering, or temporary eviction protections, and there's really three. The Los Angeles County eviction moratorium, which is really the last one covering non-payment of rent, or at least the last broader protection for non-payment of rent. The very limited and narrow Santa Monica moratorium for rent-controlled tenants. And then the third one is the kind of ongoing protections against eviction for reasons other than non-payment. That's section 4, the change to the maximum rent control increase. Obviously, we just had a great presentation on that, so I'm not going to be focusing on that as much. And then I want to go over the resources that we have here in Santa Monica. Okay, so I just want to start with a reminder. When we talk about eviction moratorium expiring or temporary protections expiring, it's always important to kind of remember that we have a lot of protections both at the state and local level that are permanently in law. So I'm not going to go into a ton of detail about these, but it's always worth a reminder. First of all, oh, um, there are, you can never lock out a tenant who's ever kind of been authorized to be there. You have to go through the specific legal process and all of the protections that go with that. Of course, in Santa Monica, we have rent control and just cause for eviction. Even for some tenants who are not rent controlled, they're covered by our very protective just cause for eviction ordinance. The Tenant Protection Act, and those are those statewide protections. And very often the local laws are going to be more protective, but there may be some units that, for certain eligibility reasons, are covered under the state law, but not under local protections. And that also both sets a cap on annual rent increases and provides, you have to have a specific reason to be able to evict someone unless they fall into an exemption. We have permanent and temporary tenant relocation that are triggered by different circumstances. The strict requirements for buyouts and the buyout ordinance for rent-controlled tenancies. And then as long as there is a city or state state of emergency, there are ongoing rental housing price gouging protections, which generally create a cap of a 10% rent increase. So if we could go to the next slide, please. Okay, so the first one I want to talk about is the county moratorium covering non-payment. And this is really, again, the last moratorium that kind of provides broad protections for inability to pay rent due to COVID-19. And so it covers rent due from July through December, and then it will no longer be in effect after December. And as I'll talk about with the next slide, there are eligibility requirements for this for these protections. So there's kind of three main qualifications that are very important for the county eviction moratorium. And the first is that the tenant has to provide notice to their landlord within 7 days after rent is due every month that rent is due. So that, has probably, time period has probably already passed, although, it could be that a tenant is able to pay the rent up until now, depending on what their lease says. The inability to pay must be due to financial impacts related to COVID-19, and both financial impacts and related to COVID-19, those are terms that are defined in that county ordinance. And then you have to meet a specific income threshold to qualify, and the next slide will show you what those numbers are. And so here, this is just a chart that goes over the income threshold. You have to be at or below 80% of area median income. Of course, I don't expect you to remember that, and we're going to go over the city website and the county website that has all this information, so you can go back to that. Okay, so in terms of repayment, it's not, as we've been saying for quite a few of these, it's not that the rent is waived. The tenant still owes the unpaid rent. A tenant has until 12 months after December 31st, 2022 to pay that rent. Non-payment is not grounds for eviction, but landlords can bring an eviction case and try to prove in court that the tenant didn't qualify for the protections. And so it can be complicated. It should really be a last resort, and it's as always, very advisable if you're invoking the moratorium or of course, facing eviction or worry that you will be to seek legal advice or help from legal aid. Okay, so December rent. I want to clarify this because there was a time when our website discussed the effects of a lawsuit. And so the short update there is basically that the Board of Supervisors at the county level responded to the concerns of the court. And so now, although it appeared possible that it would not cover December rent, the county moratorium does cover December rent. The currently applicable county protections, there is the county website. We also link to the full text of the resolution on that city eviction moratorium page, which we've tried to keep update for several years now. Okay, so resources and just kind of reminder here that this program was enacted by and is run by the County of Los Angeles. So even though it applies in Santa Monica, it's not a program that was passed by our city council or our voters. It is a county program, and so questions should first be directed to the county um, at the contact information that is there. And you can also, we do summarize the protections on our website, but for kind of a more thorough explanation and links, you should go to that county website that's listed there. All right. Okay, so now I'm going to talk about the limited Santa Monica moratorium for rent-controlled tenants. And really, this is, I'm glad that I'm following Dan's presentation here, because really this is designed to be kind of a layer of protection that coincides with the way that new ordinance that was passed by, or charter amendment that was passed by the voters. And so these protections cover rent due between September 1st, 2022 and January 31st, 2023. And so that, if you recall, that's that initial period when landlords were, at least in theory, able to raise the rent for rent-controlled tenants by the full 6%. And if you recall, starting February, that's when they have to lower the rent down to just 0.8% above what it was before September. And again, I know this is confusing, and we can try to explain it again during question time. But the design of that is to make sure that the average rent over that period was 3%. And so to qualify for this very narrow moratorium, you have to be a rent-controlled tenant. You have to have received an increase of more than 3%, as compared to that baseline before September 1st, 2022. Non-payment had to be due to COVID-19 related financial distress, and you had to provide notice and documentation of inability to pay. But notably, it doesn't apply if the landlord lowers the rent below the threshold or accepts the rent below the threshold. And again, that's the 3%. And so if the landlord basically voluntarily, even before that February date, said, I only need rent that would be just 3% above what it was before that September date, or if they officially lowered the rent, then this moratorium wouldn't apply, because it's really designed to protect those tenants who got the larger rent increases. So we can go to the next slide. Okay, so all of that said, if a tenant is covered, it applies to all of the rent for the covered month, not just the increase amount. It's an affirmative defense if the landlord brings an eviction case. And tenants have until September 1st, 2023 to pay it back. So that's important to look at that date. That's not the same as the county moratorium. It's not a year after, the final possible date for the moratorium. Rather, it's kind of the next rent control year. So that's a fixed date. It's September 1st, 2023. It can be paid back in multiple payments or a lump sum. If the amount is paid back, then the tenant can never be evicted for it. However, if they don't pay it back, then a landlord could bring an eviction after that September 1st, 2023 repayment deadline. Okay. So now the sort of temporary protections or moratorium that people may be most familiar with that we've had for some time now, the Santa Monica moratorium for eviction for reasons other than non-payment of rent. So it says at the top of our website, and we're reminding you again here that that's now been extended through February 28th, 2023. Of course, it could be extended again, but that's the current date. It covers those 5 things: no fault evictions, since for nuisance, unauthorized occupants, and pets, and Ellis Act evictions. It's the same kind of general rule for Ellis, which is that you can serve the sort of necessary notices, under that law for that process, but you cannot bring an eviction until 60 days after the expiration of the moratorium, which would currently be that April 29th, 2023, unless that is extended. And my colleague's going to be talking more about this later, but I'm just noting there was a requirement to send copies of eviction notices and lawsuits to a city email address, and that's now been put into city law as a permanent requirement, and we're going to be hearing about that more later. And so this is just a graphic that you may have seen before. I'm just kind of going over what those protections cover. Some time ago, the sort of extra protections for denying entry to the landlord, those were phased out. It's worth bearing in mind that, of course, there are strict requirements in terms of reasonable notice, usually 24 hours, and specific reasons why a landlord could enter that are permanently a part of the law. These were just the extraordinary sort of extra and special protections that were phased out. But the other protections will remain in effect through February 8th, 2023. Okay, so I'm gonna go ahead and skip this slide. Again, we just had a whole presentation on this, but that was the rent control change. And then just a reminder about the resources that we have. So kind of the first thing to do if you have a question about all of these is to just Google Santa Monica Eviction Moratorium and go to our website that we try to keep updated and sort of spell out in clearly understandable terms, all of those different temporary protections that are in effect. Again, if you need to contact the city, you can do so through the 311 program, and all of that information is there. And then, of course, if you're a tenant that is, particularly if you're facing eviction or worried that you may, or you've received a notice, you should contact legal aid. And then there's Betsedic Legal Services, which is another legal aid organization. Okay. And so, I think I'm not going to actually go to the website, but I just wanted to reiterate that again here. I would encourage everyone to kind of use that as the starting point when you're encountering these issues. And that is everything. Thank you.
Thank you, Jonathan. So next up, we have Deputy City Attorney Autumn Rindels. She'll be presenting you with a brief review of buyout offers and compliance with the Tenant Harassment Ordinance.
Thank you so much, Bridget. Let me share my screen with you. So this is going to be somewhat quick, but I definitely think that it's worthy to talk about it because there's been some issues and questions that we've had recently about buyout offers and how that's applicable to our tenant harassment ordinance. So just for what we'll cover here quickly, I'm going to go over the scope of the law, and there's a disclosure prior to buyout offers that must be given to a tenant by a landlord, and what those requirements for there are requirements that need to be part of your actual buyout agreement, and there is an opportunity for a tenant to rescind a buyout agreement. And lastly, a landlord does need to file a buyout agreement when everything is all said and done. So first of all, where is the buyout agreement provisions within the tenant harassment ordinance or within our Santa Monica Municipal Code? The section is 4.56.050, and that deals specifically with buyout offers. And again, that is housed within our tenant harassment chapter 4.56. So that means specifically that if you are, and I'm talking about landlords, or if a landlord is violating these buyout ordinances, it could be a violation of our tenant harassment ordinance as well. What is really important to understand, though, is who is covered by, and I'm going to just shorten it, and I'm going to call it 050, but who is covered by 050? It is specific. It is for only controlled rental units, and another way of saying that is for rent controlled properties or rent controlled tenants. It does not cover market rate tenants. So let's talk about the disclosure, and all of this also can be found within 050 subsection B, but there is a disclosure that must be provided to a tenant prior to even getting into a buyout agreement or even having an agreement put forth. And as part of that, there are essentially 4 statements that have to be part of that agreement, and that's what's on your screen right now. There has to be a statement that the tenant has a right to enter into has the right not to enter into a buyout agreement. The tenant may choose to consult with an attorney. The tenant also may rescind a buyout agreement within or for up to 30 days after it's fully executed. And the tenant may visit the Rent Control Board for more information about the buyout agreement in the tenant's neighborhood and other relevant information. And something that is really important to note here is that this is not simply a disclosure that you hand to a tenant and walk away. In fact, there actually has to be a signature and date line for the tenant to basically say, yes, I've read this, I agree, or I understand, and have them actually sign it. In addition, the landlord needs to keep even just this disclosure for up to 5 years. So if you get past that disclosure and you are ready to sort of talk about the actual buyout agreement, very similar to the disclosure, there are some statements that are mandatory to be part of that agreement. And if they're not part of that agreement, then the agreement is not effective and the tenant can rescind it at any time. There's no deadline for that. So just make sure that you pay attention. First of all, the agreement cannot be oral. It has to be in writing. And you can't do it over the phone. You can do it in person, but still it has to be in writing. And the following statements have to be part of it. And they're very similar and almost identical to what had to be in the disclosure. But if you look really carefully, there's also additional requirements. There is a font size that has to be met, which is a 14-point type font. And that is so that a landlord doesn't hide these statements within different portions of the agreement or makes it really small so the tenant may not read it. Additionally, the statements also have to be in a very specific place, and that place is right near or in close proximity to the actual signature line for the tenant. And those 3 statements, again, very similar, almost identical to the disclosure, is that a tenant may cancel the agreement in writing at any time before the 30th day after everyone is signed. You have a right not to enter into the agreement, and you have the right to consult an attorney or the Rent Control Board, as previously stated. All of this language is directly in 050 subsection C. So you can, if you're a landlord or if you're a tenant and you want to make sure that the agreement is sound, go ahead and visit this particular section, and it has that language in there for you. Now, can the buyout agreement be rescinded by the tenant? Yes. But there is a time limit to that, as long as the agreement satisfies all those requirements I just talked about, and that is up to 30 days after its execution by all parties. So a tenant has 30 days to think about it, sort of a safe harbor provision, if you will, and they can rescind it really for any reason if they decide they don't want to go forward with it. However, there are some requirements regarding that rescission. It needs to be in writing. So a tenant must hand deliver, email, or place in the U.S. mail a statement to the landlord indicating their intent to rescind the buyout agreement. Now, what happens after everything is said and done? You've gone past that 30-day safe harbor provision. The landlord does have to file the buyout agreement with the Rent Control Board, and the soonest, though, a landlord can file that is the 31st day after the execution of the agreement, which means the day after that 30-day safe harbor provision expires, but no later than 60 days after the agreement is executed. So you have that sort of the second month time period for a landlord to file that with the rent control board. Lastly, again, this falls under our tenant harassment ordinance. So if a landlord fails to follow those provisions that I just have gone over, then this could possibly lead to a tenant harassment violation, which can then also lead to administrative, civil, or criminal penalties. I went through that very fast, but the city, as with a lot of our other resources, has a website that can walk both a landlord or a tenant through these steps and tell you exactly what you need to do. And this is the website to do that. And I'm going to just really quickly bring up that website for you as well. So just give me 1 second. So here is the website, and it's labeled "What Owners Must Do If They Offer a Buyout Agreement," and it goes over everything that I just went over with you, and it has an FAQ for some of the questions that you might have. It allows you to download an information sheet, and it walks you through step by step what needs to happen. And this can be both a reference for tenants and for landlords. If you have questions, feel free always to reach out to our office. But most importantly, you may want to reach out to Rent Control themselves, and it provides you the number here, or you can also reach out to them by email. So I hope that's helpful. It's pretty straightforward. And if again you have any questions, please reach out to the city.
Thank you, Autumn. Next up, we have Deputy City Attorney Gary Rhodes. Gary will be giving us an update on the recent revisions of the Fair Housing and Tenant Harassment Ordinance. Gary?
Yes, I am here.
Okay.
Can you hear me?
Yes, let me just turn your
Great.
camera on. Okay, take it away.
All right, good evening, everybody, and thanks for patching in, whether you are a landlord, a tenant, or an advocate to learn more about rights and obligations under our city's laws. Our division, the Consumer Protection Division, is uniquely positioned to counsel the city or advise the city council on any changes that need to be made to our tenant protection laws, because we take complaints, we investigate them. In some situations, we litigate them. We work with groups like the Legal Aid Foundation of Los Angeles and the Rent Control Board on a regular basis. So we're in a good position to advise council on what is needed in Santa Monica in terms of any changes to our tenant harassment ordinance, our fair housing ordinance, or our tenant protection ordinance. And so I'm going to summarize the amendments that were made in 2022. So if you could, next slide, please. Okay, these first two changes were made to our tenant harassment ordinance. And this first set is a set of examples of coercive harassment that were added to clarify the law. Now, they were added only to explain the existing law. These examples did not suddenly become illegal in Santa Monica in 2022. We added them to make the law more clear. We want our laws to be plain enough so that anyone, not just the lawyers that write them or draft them, can easily understand what is prohibited. So among those examples of harassment that are potentially unlawful under our harassment ordinance are excessive rent increases, such as when a landlord would increase the rent so much, even though it is probably unlawful, with a notice, hoping that the tenant will just shrug and leave because they know they can't pay the rent and they can't fight the increase. The next example, baseless threats to evict. These are, again, usually served in notices, but sometimes orally. If it comes with the landlord's intent to drive the tenant out so that they don't have to deal with rent control laws or the state's eviction unlawful detainer laws, that is another example of coercive harassment. Threats to report immigration status. Now, we actually have seen that in Santa Monica. We filed a lawsuit about a year and a half ago and obtained a judgment and injunction against the landlord who had threatened to report her tenants to the law enforcement authorities because she believed that their immigration status might get them out of their unit faster than she could do it with an eviction. The next example, terminating a tenancy on a fraudulent basis of owner occupancy. You heard from Dan that this owner occupancy restrictions or the possibility of owner occupancy is tightened a little bit, but we have had in our office cases and even litigation in which an owner had said in a notice to a tenant that they were going to move a relative into the unit, and the tenant went ahead and moved, and lo and behold, the landlord never did invite or never did bring in any of his family or himself. He just fixed up the unit and raised it to market rate. That has always been fraud under our ordinance, and now we're providing the specific example right there in the ordinance for anyone to read. And then finally, excessive and baseless entries by landlords or their agents. Those would include entries without notice and without justifications. And of course, we know those happen all the time, but if it looks like the landlord has been doing it and knowing that it harasses or annoys or intimidates the tenant, they've heard from the tenant on that basis or the tenant's advocate, then at that point they are not only in violation of Civil Code 1954, which has always prohibited baseless entries, but they are now in violation of our harassment ordinance. The next amendment that was made to our tenant harassment law was that we added protected classes to its fair housing section. Now, you may ask, why is there a fair housing section in the tenant harassment law? Don't we have two different laws, one to deal with fair housing and one to deal with tenant harassment? Well, our harassment law incorporates or borrows into it all the fair housing laws that exist in this jurisdiction, which includes our local fair housing laws, the state fair housing laws, and the federal fair housing laws. So a violation of any of those against any protected class would, if it's done in bad faith and an intent to harass tenant, will become a violation of our tenant harassment and would be another claim that the tenant might have or that the city might have. So this year, we added some protected classes to that group of protected classes, including source of income, immigration status, gender identity, gender expression, and in language that now broadens or expands our prong here to any protected class under local or state or federal law. And of course, if any of those laws add protected classes in the future, they will automatically be incorporated into this section. So with the next slide, I would just like to show you all where the tenant harassment ordinance is now. Here's the summary of prohibitions in layperson's language, and it is in the red enhanced sections that we made those amendments. So you see the first one that is in orange, I suppose that's orange. You see that those examples I discussed, like threats to report immigration status or baseless threats to evict, all those examples were added right there to that part of the ordinance. And in this slide deck, which we often get requests for our slide decks from attendees, at the end of it, I've provided the actual laws so that you can see what they say as well. This happens to be a summary. And then here in the next orange enhanced provision, you see the list of protected classes, how they were expanded right there in that section. So I'll just add that the most common harassment complaints we get are included those unjustified entries that I talked about, and coercion and intimidation and discrimination, along with failure to make repairs and bogus eviction attempts. All right, next slide, please. We, in 2022, we also made amendments to the Fair Housing Ordinance. And the fair housing is another way of saying, addressing housing discrimination. And so both of our amendments in 2022 clarified how our prohibition against housing voucher discrimination works. And you may, especially if you've attended previous workshops, since 2015, we have usually included how discrimination against the recipients of rental assistance works. And you may remember that in a pioneering move in 2015, the City Council banned housing discrimination against recipients of rental assistance, such as housing choice vouchers. And this would also include grants for rent assistance by nonprofits. It would include any other rental assistance from governments, such as the rental assistance that came down during the pandemic period through the Housing is Key program. All the recipients of that assistance were protected against housing discrimination. And of course, the most common type of discrimination there is just the landlord refusing to accept it and really putting the tenant in a spot where they need the assistance. They proved they need the assistance to some agency or nonprofit, and here their landlord is refusing to accept it. So the clarifications that we made in our law, and again, the law has always included this, but we're making it very clear for landlords and tenants so they know their rights and obligations. It was clarified to say that this includes applicant and existing tenant situations. The second clarification we made was that if a landlord doesn't say no to rental assistance, but just refuses to respond to requests about it or to the paperwork that needs to be filled out to get it going, that refusal or that delay in response is also considered discrimination under our law. And by the way, it's also discrimination under state law. The state amended its law 5 years after the city did to finally include this type of discrimination as being protected. Okay, next slide, please. The last ordinance that we amended this year was the Tenant Protection Ordinance, and that's at section 4.27 in the code. The first piece was, as Jonathan alluded to in his presentation, was that what was formerly an emergency order during the pandemic that required landlords to report all eviction attempts that they make, whether it's a notice of termination or an unlawful detainer that they filed in court, they have to email those to the city. And the email address for that you see is emreports@santamonica.gov. Now the reporting requirements not only include the notice and the complaint itself, but we also want to know what the outcome of the case was. We want to know whether each side was represented by counsel and whether the tenant qualified for fee waiver. This is all to help the city better figure out how to handle the issue of evictions and its impact on our community. And it's not, by the way, it's not a defense in an eviction for the tenant if their landlord fails to report the violation. So it's usually an administrative citation for a fine, up to $1,000. The second amendment that we made to the Tenant Protection Ordinance, and these are adding new areas of concern as opposed to clarifying like we did in the first two examples today. This is another new pattern that we saw happening between landlords and tenants in our community. The landlord sends the tenant a notice that the attorney's fees provision in their lease was going to be changed, say that either no attorney's fees are available in any litigation between the two parties, or that they're capped at, for example, $500. Those notices to change the lease did not ever mention the fact that our Tenant Harassment Ordinance and our Fair Housing Ordinance and almost all civil rights laws shift the attorney's fees, the responsibility for attorney's fees, to the losing party at the end of a case, whether it's been dismissed or lost in a trial or a jury trial. So we saw these notices and these attempted changes to lease as things that would confuse the public and even attorneys. Attorneys might see this notice and they may not understand that our ordinance says that the attorney's fees must be paid to the prevailing party, and no change in the lease can affect that law. So from now on, when a landlord tries to change an attorney's fees provision in a lease, they have to provide a notice that puts the tenant on notice that this cannot affect our two laws here in Santa Monica that already provide for fees. And all right, so that's it with those two amendments. Next slide, please. Okay, so I'm not going to go through these slides. I've just provided them in case there's requests for the slide deck that you can see our full ordinance and with the new amendments in the orange color, and so that you can better see the context for each of these changes. And if we could go down to the final slide. Unfortunately, I have a board meeting that I must attend, and so I'm not going to be able to stay for the question and answer period, but my colleagues will be able to answer questions about this. And if you have any questions that you don't get to ask tonight, or if you think of them later about these amendments, please email me at gary.rhodes@santamonica.gov. Thank you, everybody.
Thanks, Gary. So next we're going to have two gentlemen doing a joint presentation. Dan, who I introduced you to earlier, Dan Costello, and Armando Rangel from the city's Code Enforcement Division. He's one of the supervisors there, and they're going to be talking to you about maintenance and repairs. Let me just get this slideshow going here. Sorry guys, it's taking a minute for PowerPoint to open here. Okay. Okay. Go ahead, guys.
Thanks. Is my video on, Bridget?
Yes, we can see you.
Okay, great. Okay, so I'll just start for us, but I think it's apparent from the presentations by Jonathan and Autumn and Gary that there are a lot of areas where the city attorney's office and rent control work together. And in that same way, we also work very closely with code enforcement, particularly regarding the maintenance of residential rental property. So I'm here with Durangel to tell you about that. So if we go to the next slide. So as I said, we work cooperatively to address the maintenance issues that come to us. And they may come in to code enforcement or they may come into rent control. And we are often making referrals to each other to handle various things. In today's presentation, we will cover just a couple of things. Very briefly, we don't have a lot of time. We have in years past done a joint seminar on the maintenance of residential rental properties, and you can view those on the seminars page on the Rent Control website. But today, what we're going to go over very briefly are what are the two different agencies' enforcement processes, and then we're going to go through some of the common maintenance issues that we hear about and give the tenants here some direction on which agencies they should contact for the different issue. In addition to our two municipal agencies, there is also the LA County Health Department. And for a lot of the things that come to us, it would be a good idea to contact the LA County Health Department as well. And we'll give you some examples of why you would want to do that toward the end. So I'll turn it over to Armando and go to the next slide.
Good evening, everyone. Again, my name is Armando Rangel, Code Enforcement Supervisor here with the City of Santa Monica. And I'd like to start by just providing a simple definition of what a code enforcement officer is, particularly here in Santa Monica. A code enforcement officer is a non-sworn employee of the city who possesses specialized training in the prevention, detection, investigation, and enforcement of violation of laws, regulating public nuisance, public health, safety and welfare, public works, regulated business activities, consumer protection, building standards, land use, and municipal affairs. And what is it that we do in a nutshell? The code enforcement team helps maintain and improve the quality of Santa Monica's neighborhoods by operating programs that ensure compliance with the city's municipal code. Additionally, we respond to consumer complaints of potential building, plumbing, electrical, and health and safety code violations and initiate fair and unbiased enforcement action to correct violations identified by our code enforcement staff. The Santa Monica Code Enforcement Division is under the Community Development Department. And as the slide states, property owners must maintain housing according to minimum standards set by the California building codes, which are typically governed by city employees, California health and safety codes, which are typically governed by LA County health inspectors, and Santa Monica municipal codes, which are again typically covered by city employees. And we'll get into a little more detail in the next few slides. Next slide, please. Complaints to our division go to the Code Enforcement Division can be submitted through the 311 customer service portal, by telephone into our division office, by email, or in person at the City Hall front counter. Our contact information will be provided later in the presentation. Generally speaking, when a citizen submits a concern regarding a property maintenance issue, our administrative staff receive the concern to verify if it is a property maintenance issue related to a building code violation or an interior health code violation investigated by the county health department, or a substandard condition that may render the unit uninhabitable and unfit to live in. Interior health code violations are referred to the county health department for investigation. Again, generally speaking, when we receive a concern regarding a property maintenance issue related to building code violation, code enforcement staff will open a case and assign it to a code enforcement officer for investigation. And as part of the initial investigation and inspection process, the officer will typically contact the concerned party if needed to obtain further information and schedule an inspection. When a violation is identified by our code enforcement staff, the officer will issue a notice of violation of the property owner, informing him or her of the violation, along with instructions on how to correct the violation. Reasonable time is provided to ensure the violation is corrected timely. Our goal is always to gain voluntary compliance when possible, to avoid enforcement action. When violations are ignored or not corrected within the allotted time frame, administrative citation, a fine, is issued to compel performance. We can issue up to 3 administrative citations. We can issue up to 3 administrative citations with escalating fine amounts until the violations are abated. Additional enforcement action to compel performance may also include criminal, civil prosecution, recordation or a lien against the property, court order receivership, and abatement. Again, our goal is always to gain voluntary and swift compliance. Next slide, please. As previously mentioned, our office also investigates substandard conditions that may render a unit uninhabitable or unfit to live in. In certain situations, when a unit becomes uninhabitable, a landlord is required to provide temporary relocation benefits to the affected tenants. A habitable dwelling unit correctly provides basic protection, sanitation facilities, and access to utilities such as gas, water, and electricity. An uninhabitable unit is unfit to live in due to the conditions that endanger the life, limb, health, property, safety, or welfare of the occupant. The purpose of the tenant relocation program is to prevent temporary homelessness when tenants must vacate their homes due to a substandard condition that render their homes temporarily uninhabitable. It also reinforces a tenant's right to return to their home once habitability is. Next slide. Examples where the landlord is required to provide temporary relocation benefits to a tenant are when a building is tented, for example, for fumigation purposes, building code violations that create unsafe or dangerous living conditions, lack of hot and cold water, lack of adequate heating facilities, or lack of a bathroom. If you have one bathroom and your bathroom is not usable, that could also render the unit uninhabitable. Benefits are not required if the condition that caused the unit to become uninhabitable was caused by the tenant or the tenant's guests. Next slide, please. When a unit is declared When a unit is declared uninhabitable by the city, code enforcement staff will issue a formal habitability determination and relocation order prompting relocation benefits. When temporary relocation benefits are required, the landlord is given the option of providing one of the following benefits. When it is estimated that the condition will take less than 5 days to repair and restore, the landlord may provide the tenant with a hotel or motel, or comparable housing, or the daily per diem rate. Currently, the daily per diem rate is at $354 for a hotel or motel, $38 for a meal per person per day, $1 for laundry if laundry is provided on site, $64 for boarding a dog, $35 for a cat. When it's estimated that the condition will take more than 5 days to repair and restore the habitability, the landlord may provide the tenant with, there's two options, comparable housing or the daily per diem rate. In this situation, a hotel is no longer an option. When it's estimated that the condition will take more than 30 days to repair and restore habitability, the landlord must provide one of the following. This is for more than 30 days to repair and restore. The per diem rate, which is paid in weekly increments, or comparable housing. Thank you.
Thanks,
Dan?
Armand. Yeah, so thanks, Armand. We can go to the next slide, please. So I'll talk about the way that rent control handles maintenance issues. Bridget, if you want, you can just open up all the bullet points on this slide, and then I'll go through them. So the very first step is that tenants need to give a written request for repairs of deteriorated conditions to their property owner or landlord. It's very important to keep an exact copy of this written request because tenants will need it if they end up filing a petition with us. So the whole process starts by making a request to the landlord in writing. Email is an acceptable way to do that, but text messaging is not. So if you send an email, that's easy to have an exact copy. If you write to the landlord, you can do that. You don't need to send it certified mail, just send it to the landlord, and we'll have you complete a proof of service that you indeed did that. But we do need to see an exact copy of the notice that was given to the landlord. I will note there that a code enforcement order can also be used as a notice to the landlord. So for us to be able to take an issue on a petition, we have to determine whether or not it was a base amenity. And this really depends on when the tenancy began. So, and this is the difference between tenants who moved in before January 1st, 1999, those who moved in afterward. Everybody who moved in before January 1st, 1999 goes back to the original amenities that the unit had on April 10th of 1978. That was 1 year before rent control started, and owners had to register what those amenities were. You can get a copy of that registration form by contacting our office. It's not an exhaustive list. It does cover things like carpets, drapes, screens, stove, utility, owner paid utilities, furniture, things like that. But it's a good source of what the original amenities were for pre-99 tenants. And it is presumed to be correct. One thing I'd like to point out, though, is some tenancies began after April 10th of 1978. And tenants may have had an amenity that came with their unit when they moved in. That does not mean that that is a base amenity. So maybe the unit did not have parking in 1978, but the owner gave it to the tenant in 1985 when they moved in. Rent control would not be able to do anything about that because the base rent, which is tied to those base amenities, did not include parking. So sometimes there's a difference between the base amenity and what a tenant may have gotten when they moved in, if they moved in before January 1st, 1999. After 99, whatever the tenant had when they moved in is a base amenity. And if parking, storage, or the right to have a pet is added to that tenancy, then that too becomes a base amenity. So we take petitions for base amenity issues. And the process is you give the notice to the owner about the condition or the amenity, and then you have to wait 30 days. And that gives the owner opportunity to address the issues that are raised in your notice, or to do repairs or schedule a contract or whatever they have to do. But if after 30 days there are issues that are outstanding, the tenant can file a petition for rent decrease with our office. We encourage you to contact us if you're going to do that. Please call us and we will schedule an appointment with you to make sure that the petition is filled out correctly and that you have the necessary documentation. You have up to 180 days to, from the date of your notice, to file one of these petitions for rent decrease. If your notice is more than 180 days old, we cannot use it to file a petition. You will have to re-notice the landlord. If you file a petition, the first thing we do is try to mediate. So a mediation conference is scheduled, and I can tell you that this is a very successful program, and most of the time our mediator is able to resolve the issues between the landlord and the tenant. In fact, last year, 61% of the petitions that were filed, decrease petitions that were filed, were fully resolved in mediation. So if the matter is resolved in mediation, a written settlement agreement is signed setting out what will be done. But if there are issues that are not resolved in mediation, then we will schedule a hearing. And a hearing officer will take evidence and write a decision that will, which could reduce the rent for the tenant for each one of the conditions that is found. Then the hearing officer will issue this decision, and either the tenant or the landlord can appeal it, and they would ask the rent control board to give a final decision on the issue. Okay, we can go to the next slide. So Regulation 4200 sets a decrease range for many possible issues. So this means it sets out a specific dollar amount range for, say, parking or carpeting or deteriorated cabinets. And the hearing officer can determine, generally within that range, what would be the appropriate amount of a decrease to the rent based on the lack of maintenance or limited housing services or amenities being taken away. They can go above or beyond that range if there is good cause. But I think the key point to take from this is that, unlike code enforcement, rent control can only affect the rent for the unit. So we try to maintain a fair balance between the amenities and the services that are provided with the dollars that are paid by the tenant. So if a decrease petition is granted, those decreases remain in effect until the owner rectifies the issues and requests a compliance determination. So we can go to the next slide. There is another type of decrease petition that we hear, and those are related to construction on a property. The process is a little bit different from the regular rent decrease petition. Rather than the tenant notifying the owner of the issues, the tenant notifies us at rent control that substantial repairs or rehabilitation or upgrades are planned or are ongoing. And then we will look at the severity of that. And if it seems like there's a problem, we will mail a notice to the landlord informing the landlord that the tenants, I should say we will mail a notice to the landlord and the tenants that the tenants could file a construction-related decrease petition. Again, mediation can be scheduled for these, and it's often very successful as well. These petitions are very detail dependent, and again, if a tenant is thinking about filing one, we definitely encourage you to contact our office and meet with an information coordinator or analyst, and they'll help you complete the petition form. In this case, the decreases are effective from the date the condition began, rather than in a regular decrease petition, it would be the first rent payment 30 days after. I'm sorry, the effective from the date that the petition was filed, and it takes effect 30 days after the decision. Okay, if we go to the next room. So these, we can only grant a decrease when a unit is uninhabitable due to construction, or construction substantially reduces a housing service, or construction interferes with the tenant's ability to occupy the unit as a residence. But we cannot grant a decrease for unavoidable construction impacts caused by necessary repair or maintenance unless it's conducted in a manner that is unreasonable or it takes an unreasonably long time to complete. So those are the two types of decrease petitions that we have. For construction decreases, sometimes the amount of the decrease is a percentage of the rent. Sometimes it's a dollar amount. Okay, and we go to the next slide. So we want to go through some common maintenance issues that we hear about a lot. And Armando and I will go back and forth between these. So carpeting or flooring. So this is damaged or missing carpets, padding, hardwood, laminate, tile, linoleum, trip hazards, faded carpeting, floor structure, of course, tears, rips, hold, worn thin, all the kind of conditions that carpeting might have, or wood flooring as well. Rent control can address some things that may not be violations of the building code or be a health code violation, and that they're somewhat cosmetic. But that's because becomes this imbalance between the amount of rent that is paid and the quality of the amenities for the unit. Code enforcement can also handle these kind of things, but when they rise to the level that there is a safety concern, or the unit might even become uninhabitable.
Yeah, so generally speaking, the floor coverings would be like the carpet, the tile, the linoleum, et cetera. Those things are covered by the county health department. However, damaged floor structures, including the framing wood members or the foundation, the items under that covering, if you will, that's something that code enforcement could get involved with and investigate, and it could be potentially a code violation for us.
Okay, next. So paint and wall coverings. Similarly, if it's deteriorated paint, if it's worn thin, mismatched colors, things that just don't look right, wallpaper that's peeling, rent control can take a decrease petition on these. Armando, do you have anything to add to this?
Yeah, for us, we go between the county health department and code enforcement. So the county health department will investigate issues regarding maybe chipping paint, deteriorated walls, the chipping paint and drywall around maybe a window. Code enforcement will investigate major interior, exterior wall issues, large holes, for example, that allow the elements of the weather to enter the unit. Something like that could be deemed some substandard and could render a unit uninhabitable, triggering temporary relocation benefits.
This next one is a very difficult subject to deal with, but it's mold, and we hear about it a lot, so I think we have to address it here. Armando, do you want to take this?
Sure. So visible mold, here in code enforcement, we will investigate concerns regarding mold. It is a violation of the County Health Code 17920.3. So visible mold is investigated by the County Health Department. However, a substantial amount of mold could render a unit uninhabitable and trigger temporary relocation benefits. So ideally, we ask that you contact the County Health Department, and if you believe that the mold that you see is a substantial amount, you can call our office. We'll ask questions, we'll vet the call, and if we feel that we need to go out and conduct make a habitability determination, we will certainly.
And rent control can deal with mold as well, but we're third here on the list because our process takes some time. It's not the ideal way to deal with the mold or the causes of the mold, which usually have to do with some sort of leak, why there's moisture present. We do require that if you have mold as one of the conditions on your decrease petition, that you also get a professional analysis, because the code, the hearing officers here at Rent Control are not mold experts, and so they need to have a professional report before they can grant a rent decrease, or it could affect the amount of rent decrease that they grant. Okay, next. Armando, this seems like a good one for you to start as well.
Building structures, yes. So damaged or deteriorated stairways, balconies, and landings can be investigated by code enforcement staff. Building permits could be required for the repairs. So, if you have a damaged balcony or stairway or landing, that's something that we would want to take a look at and conduct an inspection for that. Damaged or deteriorated roofs that leak, entryways, and overhangs, again, that could be investigated by code enforcement because the repair could require a building permit. In some extreme cases, especially for like a roof leak, it could compromise the habitability in the unit, and it could trigger temporary relocation benefits. So you can call our office and we can certainly take a look at that. The health department also investigates these areas, so there's a lot of overlap between code enforcement and the health department. So it wouldn't hurt to contact the health department if you have an issue regarding the building structure itself in these areas, particularly with exterior weatherproofing. That's something that the county certainly looks into. But yeah, you can call our office and we can sort through the concern and figure out if we should take the lead on it, or if it's a county health, something that the county health department could look into.
And for rent control, decreases can be authorized for external issues as well. So not just what's inside the unit, but the exterior of the property and common areas. This is an example of that. I don't think you'd want to call rent control, though, given our long process, if you've got something that seems like a structural, some structure is compromised in some way. Okay, next.
Plumbing. Plumbing, it could be, again, it's an overlap between code enforcement and the health department. Inadequate flow of water is something that the county health department could respond to and assist with. No water at all no hot water, maybe because the boiler went out, those sort of things. Leaks in your plumbing system, the actual pipe, those are all things that code enforcement could take a look at. Something like no water at all, meaning both hot and cold, that's something that could render your unit uninhabitable. And again, it triggers temporary relocation benefits. No hot water if it's because the water heater went out. Again, that if the water heater is replaced, it requires a building permit. So we want to make sure the proper permits are obtained and that the landlord goes through the proper inspection process, gets that building permit final. Leaks in the plumbing, again, something that occurs, and yes, it needs to be repaired. So we can deal with all those things. Deteriorated tubs, shower stalls, that's something that the county health department could assist you with. Until that tub or shower becomes unusable, then the lack of a shower or a tub could render your unit uninhabitable and again trigger the temporary relocation.
And just like other things, rent control can take a decrease petition on this, but if you don't have working facilities, you certainly don't want to wait 30 days for a decision that would lower your rent. But we can definitely hear some cases, and sometimes the issues maybe not rise to the level of a building or health code violation, but they are cosmetic problems, like the tile around the sink is cracked, or the grouting, things like that. So these are all things that can be included in a notice to a landlord. Okay, next. So sewer and drains. We sometimes hear about waste that is backing up in a driveway or sinks or tubs that are overflowing. Again, because of this seriousness of that issue, we suggest that you call the health department for immediate restoration of sanitation. But you can include these kind of issues on a petition for rent decrease, especially for things that may occur periodically, like it happens every 2 months, hearing officer can look at that and possibly reduce the rent for an ongoing situation like that until it's rectified. All right, next.
Electrical wiring. So yeah, so electrical wiring, the wiring itself, that's something that code enforcement investigate. Electrical outlets and fixtures, cover plates, those are things that county health department can investigate and help assist with. Again, we do more of what's permitted, what was installed under the building permit when the property was built, the plumbing, the electrical, those sort of things. The code requires those things to be maintained. They worked when we gave them a final inspection and approval, and they're supposed to be maintained. And so when they go out, code enforcement can assist with making sure that those things are repaired. In terms of the fixtures and the cover plates and the outlets, it's something the county health department will address on their end.
And again, this can be an issue for a rent decrease petition. Okay, next. So appliances. So rent control can take a decrease petition if the appliance was a base amenity. So that is for tenants before 99 that it was there in 78, or after 99 that it was there when the tenant moved in. And that includes things that the prior tenant may have left. So if the prior tenant owned the refrigerator and left it, and the owner rented you the unit, including a refrigerator, if that refrigerator stops working, the tenant could petition for a rent decrease because they rented that unit with the assumption that it came with a refrigerator. So, whether this is, a stove, a garbage disposal, anything, the exhaust fan above the stove, we can take a petition for rent decrease on these issues. I was kind of surprised to see that the health department does handle this as well, but we do have a lot of cases in rent control that involve appliances. And again, since mediation is very effective, sometimes we can just get the owner to do what they have to do once they know what's required. Next. Okay, landscaping or yard services. So this can include decreased services. So, they used to come and take care of the yard once a week, and now it's once a month, and things are overgrown. Or if inappropriate materials are being stored in a common area. We have a lot of construction going on, and if the owners are, leaving all kinds of material and taking away the public space the common space that was available to tenants, these can be issues of a rent decrease petition as well. So again, it's giving notice and waiting the 30 days and then contacting us to file a petition. And Armando, do you have anything to add from code's perspective?
Yeah, from a code enforcement standpoint, I would just be careful with the personal property in common areas. If they block paths of egress, if they block stairwells, those could be code enforcement related violations, and even the fire department, the fire code enforcement related violations. So trash, litter, and debris, that's something that we also respond to, and excessive accumulation of personal property within side yards and front and rear yard setbacks. So those are zoning violations. Those are things that we also respond to.
Okay, next. I think we'll do this one and then we'll skip to the end since we're running out of time and need to have more time for questions. But as it's getting very cold here in Santa Monica, we hear a lot about issues with heaters.
Heaters.
Go ahead.
So I'll jump in on this one. So every unit by law needs adequate heating facility, and I'm not referring to. It has to be one that was installed with the building permit. We've all seen them, right? A wall heater or floor heater or something like that. And when they go out, it could render your unit uninhabitable. So it's required, every unit is required to have adequate heating facilities. And when the outside temperature falls below 60 degrees, it could render your unit uninhabitable, thus requiring temporary relocation benefits. When heaters are replaced, it requires a building permit. So we want to be made aware of it, make sure that they're installed correctly.
All right, and again, this could be a subject of a rent decrease petition. So, Bridget, if we could just jump to the end, we'll have some contact information. Rent control should know by now, 458-8751. We've had the same number. You can always call us. We answer the phone. Code enforcement, 311. And then we have the health department numbers there as well. And we can have this slide deck available to anybody who requests it also.
Great. Thanks, guys. So, and we're going to have Dan again. He's going to be showing us the Rent Control CIVICS portal.
Right. All right. Put it here. All right, is that showing up for you?
Yes, we can see the website.
Seeing the road. Okay, great. All right, so this is our CIVICS application. This is the front end of the database that we've been working on for several years in talking about, and we launched this, the public-facing portal of this earlier this year, and we have already over 850 users, and we've used the system to process thousands of forms already. So the URL I'll start with is rentcontrol.santamonica.gov. And to use the system, you do need to have a user ID. And if you go to rentcontrol.santamonica.gov, you'll see at the bottom there's a create a profile link. And you just provide your email. And if you're a property owner or manager, provide the property addresses that you own or manage. And then we will set up your account. It may take us a couple of days because we need to verify that you are the owner or the authorized agent. And then we associate those properties to your account. So let me just log in. There is a remember me here that would make it a little bit easier for you next time. You just have to enter your password. So here you'll see that you can submit a record. So if you want to file a tenancy registration form with us, or various registration forms that we have, fee waivers, or exemption applications, these can all be done within the system. And I'd like to just demonstrate very quickly a tenancy registration because that's the form that we get the most of. It's good to read the instructions. We would like you to do that. First, you have to just select the category of when the tenancy began. We've been talking about this January 1st date. And then you go to Add Primary Site. This is common across all of the applications in the system. You always need to add the primary sites, the blue button here. And it pops up this window, and our message here is less is more. So it's going to try to do an exact match with whatever is in the system. And so we suggest only entering the street number and the street name and then hitting search. Even if you're registering a tenancy, you don't need to choose the unit here. Just search, and the system will bring up all the properties that have 1221 Ocean in the name. We have Ocean Ave, we have Ocean Park. Let's say I'm doing 1221 Ocean Avenue, unit 1001. You just click that and add the site, and here you see it already added. This location box is not necessary. So then you would continue, and you'll see across the top there are tabs that tell you where you are in the application process. You'll fill out the form with all the information relative to the tenancy. You'll see they're divided into these sections: form details, new tenant information, additional information, and a certificate of information, which is your digital signature. If you don't have time to finish, you can always just save your progress. And then when you go to your dashboard, you'll see that that application that you started is available to you on your dashboard. So I'll take a second because I have a lot of applications here. So here's the tenancy registration form that I just began. If I wanted to continue, I can hit the continue button. But once you've done one, you'll see a blue hyperlink to the form. And you'll also see a status. And this status is under review. But it also says 4 pending tasks. Unfortunately, this could be a little confusing because these can refer to internal tasks and not things that you, the user, have to do. If there's something that you, the user, has to do, you'll see info needed from applicant. So I want to just show you one of a processed tenancy. So this is one that was completed already. And people have been asking us, they want to see a version of the form. So you're going to fill out those fields that I showed you below. But you can go back to your dashboard and open the hyperlink to the tenancy registration form. And then down below where it has attachments, you can download what is the version of the form. So these will, sorry, this is the tenant's copy, the letter. This would be the form. And it will give you a version of the tenancy registration form that you can download or print and keep in your records, but it's always going to be there on your dashboard. It does take up to 30 minutes for this tenancy registration form to populate. And currently we are resolving an issue because they are not populating as we would expect, but we are trying to resolve that as soon as possible. The other thing I'll show you, since we are running out of time, is that also on your dashboard, we have associated the site master, or the property that you may own or manage, and you'll see that as something called a site master. So it's not a form that you submit, but it's one of the records that we have here at Rent Control for your property. So here's one for 1431 Centinela. I'll just click on that. And this shows you what we have in our database already. Again, you'll see these different grade sections to show you what's in there. For example, site details will tell you, what was the purchase? What's the purchase date that we have? Is it properly registered? When was it registered? And if you see or that you have more current information, that would be a reason to file something in the system. Same with like a mailing address. If we don't have the correct mailing address for you, you'd want to file a change of mailing address form. And then similar to the tenancy registration form, we have attachments here. And what we have added are the MAR reports that I described in the beginning of this presentation, so that owners will know how to increase or fill out the notice of change in terms of tenancy for the tenants. So that's an attachment to the site master. And we will be attaching those related to Measure RC in the coming days. And with that, I will stop because we have still a little time for questions, but we'll get through as many as we can.
Thanks, Dan. So unfortunately, it is very close to 6 o'clock, so we're probably only going to have time for 1 or 2 questions. So if we don't get to your question, the contact information, I'll just repeat it, and I'll also put it in the chat. For rent control, you can call 310-458-8751 or email them at rentcontrol@santamonica.gov. If you want to reach code enforcement or the city attorney's office, you can call 311 and they'll direct you to the best person to answer your question. You can also email the city attorney's office, the consumer division, at consumer.mailbox@santamonica.gov, or email the code enforcement division. Their email is code.enforcement@santamonica.gov. So let's see, one of the first questions that came in was, question 1. This person says, hello, my daughter stated to me that she applied for the SAMO rental assistance. I believe it was in October of this year. She stated that she was told she is ineligible for rental assistance because she didn't work in Santa Monica, but she lives/resides in Santa Monica. It was not Housing is Key. It was not LAHD, Los Angeles Housing. It was with the city of Santa Monica. Please, may someone assist and or find out what program in SAMO denied her Santa Monica rental assistance. Jonathan, I think you were going to provide this person some contact info.
Sure. Yeah, so I think this is referring to the rent control adjustment relief program, which coincided with those eviction protections that are related to the change in the rent control law. I will go ahead and put in the chat a link to the information for that program. I will say I'm not aware of any requirement that a tenant had to work in the city. There are specific requirements related to income and having gotten a rent control increase notice. So I will put that in the chat, and we can answer further questions about that.
Okay, thank you. So the next question it said, my landlord is refusing to cash my rent payments. She's holding my rent check for the past 7 months. Etta, I think you're going to take this one?
Yes. So that sounds like it could be a problematic situation. But of course, like so many of our tenant harassment matters, it's going to depend on the facts and circumstances of what's going on. I think most of our audience members know that the city has a tenant harassment ordinance that lists a number of prohibitions, basically preventing landlords from harassing tenants as specified. One of the prohibitions is subsection K, which says a landlord may not refuse to acknowledge receipt of a tenant's lawful rent payment. So that's got to be done in bad faith. Going back to the scenario, not all refusals to cash rent payments is a violation of the tenant harassment ordinance. There may be situations, especially if there's an ongoing eviction action, where there is legitimate reason for a landlord to not cash rent payments. However, if the landlord is not cashing with no good reason, and they're doing it basically to harass a tenant, or to put the tenants in fear or anxiety, or to create a basis to evict a tenant, that could very likely be a violation of the tenant harassment ordinance. And the tenant can file a complaint with our office. We will do further investigation and take it from there. So hopefully that answers your question.
Okay, the next question is, what would be considered an extenuating circumstance for evictions for owner occupancy? Is major renovation one of them? Dan or someone from rent control, can you take this question?
Sure. It's not really a question that we can specifically answer, because it would come down to, was it a bad faith eviction, and would the tenant prevail in court on that issue? I think that what was imagined were situations, one I can think of is when an owner was going to be evicting for one of their close relatives who had a health condition and who might not even survive the 2-year period that's required. So it's hard to say exactly what an extenuating circumstance is. I don't believe that the desire to fix up the unit would qualify. The owners are required, to move in within 60 days and continue to occupy the unit for 2 years.
Thank you, Dan. And so it is 6 o'clock. Unfortunately, we do have to stop the recording. We encourage you to send your questions, if we weren't able to get to it, to our 311. The email is 311@santamonica.gov. That's the best way to reach code enforcement or the city attorney's office. Rent control is rentcontrol@santamonica.gov. I also put this information in the chat. So thank you to all the presenters and all the attendees today. And everyone have a good night. Thank you.